The opinions on this program are those of the program host and guest and not necessarily those of WPSL. WPSL does not endorse products that may be mentioned. Any reproduction or retransmission of this broadcast is strictly prohibited without written consent of WPSL. Legal questions? Ask a lawyer. Give us a call at 340-1590, 340-1590 here at the studios of WPSL. And Ask a Lawyer with your host, attorney Stuart M. Address.
Good morning, known universe. That is the scope of our listening audience. I'm Stuart Address, and this is Ask a Lawyer. And I am here to answer, hopefully, your questions, if I can, about anything you might be wondering. If you have a case, if you think you have a case, if you're going to be sued, if you have a nasty neighbor, a difficult landlord, a pain-in-the-neck boss, give us a call at 340-1590. Hopefully this week I won't have to sing to get phone calls. Last week was very successmal.
Yeah.
Twice I threatened to sing. Twice I started to sing. Twice phone calls came in to stop me from singing. So I think I now know my hook. My hook is to sing. I'm being told on the line, no, don't do it on Facebook Live. They don't want me to sing. No. I'm not so bad. Yeah, I am, really.
The day job's not bad.
Following me is Ask a Rabbi, and our rabbi has a little quip. When we have a Jewish temple, we have a Presbyterian reverend who plays the organ for us on Friday nights, and sometimes he'll ask her, what key, and she says, "It doesn't matter. I'm going to use them all."
Yeah. Pick one.
I don't think I use them all, but I think whichever ones I use are not very good. All righty. Well, let me update you folks on a little something. I've been speaking for the last couple weeks about the Lincoln Park Academy speech and debate team.
Mm-hmm.
And last weekend were the state championships of the Florida Forensic League down at Davie High School in Davie. Actually, it's not Davie High School. It was Nova High School in Davie.
Okay.
Very nice place. A lot of walking.
What is the Nova High School? Is it like part of the Nova College?
Nova High School is next to Nova Middle School, across the street from Nova University. Next door to that is an extension of the University of Florida. I don't know what's going on over there.
I didn't know they had.
And then across the street, the Davie edition, I guess, of FAU.
Yes, I go down to the dental college.
I was waiting to see Harvard. Everything was there. So anyway, we brought 5 of our students. I believe they're all 9th graders, freshmen in high school.
Mm-hmm.
To compete. And, it's a tough competition. This is state championships, and this was our inaugural year. Trying to put a team, cobble a team together, keep them together, have them each improve as you go along through the year, hopefully peak, near the state championships. And we had one young lady who made the semifinals in her category,
awesome.
Top 10 in the state. And that was exciting, and that was an accomplishment, I believe, a significant accomplishment for a first-year team, just beginning to try to figure out, how do you do all this? Because I'll tell you something. I did speech and debate for 7 years. I actually coached a year when I was at Rutgers. I coached a high school team. But it's been, 35 years or whatever since I've been involved in this. And I've never really been a coach of a real team. We have a faculty coach, who's the head coach, has to do all the paperwork and get everything approved. She had to learn this year that that's a lot of work. A lot of work on top of her normal teaching duties for no pay. It takes a lot of dedication, and she's appreciated. If not always by the students, at least by me, and those students who are aware of the effort and time she puts in.
Well, watching them learn and grow and get better is rewarding.
It is. It's been very rewarding to watch the progress, to see how, they go from 5th or 6th place in their rounds to second or third and sometimes first. It's been exciting to watch, to read the judges' comments on ballots, and to see, one of them get sixth place in a tournament, one get third place in a tournament, one qualify for the national championships, and then one this past weekend make the semifinals in the state, in her category, novice, novice state championships, but still, statewide. We're a pretty big state. Mm-hmm. It's not like where I come from, New Jersey. This is a big state, and I think to make the top 10 was one heck of an accomplishment. And I'm very proud as a coach. As the other coach, I didn't really realize just everything that was involved. And frankly, I think I may do a little coaching school over the summer because there's a lot that I don't know, and I learned how much I don't know every tournament.
Well, they're kids. They don't know you don't know.
Right. Well, yeah. Every tournament I went to, I realized what I didn't know. But next year, we should be better. We should be more organized. Mm-hmm. We should have more people because now there'll be an actual speech and debate class as an elective. So we'll have more people to mine from. And looking forward to that.
It'll also be more challenging, won't it, though,
it will
as
be
a coach?
Yeah, it will be because you're going to have those first-year people again. Mm-hmm. But hopefully you know better how to shepherd them, through their projects and through improving. And you're going to have second-year people.
Right, which will help those first-year people,
and who
too.
You're going to expect a lot more of.
Mm-hmm.
My son, for example, is actually going to do debating next year. This year was really all speech for us.
Okay.
And he's going to go to a summer camp at Nova University for 3 weeks where they're going to teach Lincoln Douglas debating and some of the public speaking, event categories. And I'm excited to see him debate. I'm excited to see him maybe argue with me a little bit better, get what he wants.
Yeah, but you should always win.
I don't know.
And no, I think, they may have a good argument, but Dad should always win. It's your house.
Well, my father always won simply by saying, "Don't you debate with me."
It's my
and
house.
my response would be, "Why not? It's just logical argument." And then I get smacked. End of debate.
Shut up, go to your room.
Something like that, But yes, it'll be more organized. We'll expect more. There'll be more rules. Mm-hmm. This year we wanted to just have a team and not have them run away. So we were very liberal and
have them run away.
And loving and, just comfy. Next year it'll be a tighter ship. And, if people don't turn things in on time, they won't go to tournaments. And next year we won't be as concerned about having people leave as we will be about organizing a real team. Mm-hmm. Because there are certain things that happened this year. I've talked to the faculty coach, and I said, we've learned some of the other coaches that exist in the area, and I won't mention them by name, but I've said to her, well, what do you think Mr. Such and Such would have done in this situation? The answer usually is they wouldn't go to the tournament. They'd be sent home from the tournament. Mm-hmm. They wouldn't go to the next tournament. Mr. Such and Such would not tolerate anything that was not consistent with his expectations.
So you guys were tolerating it to make sure they came back.
Absolutely. We tolerated all sorts of things.
Did you have any that started that didn't stay? Did you have?
We had one, but that's because, we had one, but he had a conflict in being in, I think it was wrestling.
Okay. So a teenager that's overscheduled.
Right, and we had a number. Happens. We had a number in drama who would have loved to have done some of these things with us, but they felt that their plays conflicted, practice and all that. Key Club.
What's Key Club?
Don't ask me.
Okay.
I guess that's to do with keys. I don't know that.
National
Honor Society.
I feel really dumb right now.
So one of the things we're going to try to do, particularly with a class now, we may not have to have as many after-school sessions if there's a class, and so maybe some of the students who are in other activities may still be able to participate on the team because it may be more conducive to them as opposed to having to choose between after-school activities. Mm-hmm. So it was a wonderful experience. The speech and debate year is concluded. I must say, as hard as I pushed for 3 years to get a team to be approved, I'm so happy the year is over. Oh my goodness, I'm so happy. I'm so happy I don't have to go to LPA afterwards today, for a practice, and I don't have a tournament tomorrow. I need a break. I'll gear up again for next season, but this was a eye-opening year, and it was a fun year, and you do watch them improve. And you want to know something? I'm going to give my kid a little plug. I won't tell him I said it. So, my mother and my sister are listening.
So he might find out.
I guess who's going to spill the beans, For a lot of the year, I thought that he was not improving as much as the others. And I was disappointed.
But you would be more critical because he's your son.
Yes, but in listening to him, I just didn't think I heard the improvement to the same extent that I heard others improve. And, it's disappointing, from a coach's perspective and a dad's perspective. But then, the Friday night before the Saturday state championships, at home, he decided to do his piece for me with minimal further coaching, because how much more coaching can you do the night before the state championships? And I was blown away. I had not heard him do the poetry and prose that he was using in his piece with such effectiveness, modulation of voice, movement around the space, gestures, facial expression. I don't know when it clicked, but wow, was I impressed.
Now, did it click at home? Did he have that same when he was in front of other people versus in front of just you?
Well, I don't get to see him there, but from reading the coach's comments and seeing his positioning, how he places in rounds, 2 of the 5 rounds, he came in second, out of 7 competitors usually in each round. So obviously he was doing well. One, he came in third, and clearly 2 judges didn't like him at all. That happens, you know. That's when you like them to drop the low score. But I thought that he peaked in time for the state championships, and I thought that whereas he had been behind everybody in terms of the scope of improvement, I think just in time for the state championships he surpassed everybody. And less as a coach, more as a dad. Boy, was I impressed, and was I happy to hear how good he was. And so he's excited about going to summer camp. He's excited about next year. And I'm excited that he's excited about summer camp, because I did it myself one year, when we can tell this story some other time. There's funny jokes in there. I went to Harvard for 3 weeks. And that really did prepare me for the next year, so I know what they're going to do to him. And I want them to do it to him really bad. All right. So that's enough of that. Last week, over the last several weeks, we've been talking about, different types of calls we get in the office, different types of clients, how effective we can be in trying to represent different types of people, and different personalities. And you got type A, you got type B. Sometimes an attorney and a client just don't mesh, and sometimes you can learn to mesh, and that's always a difficult thing. I would say if you go into a consultation and you really don't mesh with that attorney, don't hire him. It's one thing if you hire him and there's some rough edges, like any relationship. See if you can work them out. If you can, great. If you can't, get a new lawyer. But
I always think when you mention relationship, and I always have to go, this is going to be a relationship, because it's not quick. You don't just hire a lawyer, he does his thing, and you're done.
Usually you're talking a year, 2 years, unless it settles early, and a lot of them do. I like those what settle early.
What is early, though? I mean, it's still not a week, right?
No.
Okay.
Before a lawsuit is filed, I have cases that settle in a matter of a few months.
Yeah, I hire a plumber. He's at my house for a couple hours. You see, you hire a lawyer, it's a little different.
You get 20 emails from me, or 200 emails from me, or 500 emails from me. Yes, it is a relationship.
Okay.
So we have, sometimes we get calls, and Cheryl is sitting in the office listening. Give her a call, harass her, give her, a case you might have, or call me, obviously. 340-1590. And, we get calls from people who can't tell us the facts.
How do they know they have a case?
Well,
how do you know they have a case?
And why are they calling?
Okay.
They're calling for a reason, but when either I or Cheryl try to ask them questions to get information that will help us figure out whether they may really have a case, whether they really need a lawyer, whether or not we should suggest they come into the office for, an hour-long, debriefing.
Mm-hmm.
Some of those are free consults, some of those are paid depending upon the type of case. It is difficult when you can't really provide the facts. It's one thing when you can't remember certain dates. That's okay. We can get those later. It's okay if you say, well, approximately 2 months ago. That's fine. But when you really can't tell us any of the chronology, you can't give us examples of what you're complaining about. Somebody calls and says, I'm being discriminated against. All right, why do you think you're being discriminated against? And they launch into something that has nothing to do with discrimination, so you try to focus them. And, well, okay, let's say it's sexual harassment. The typical question is, tell me the one or the two worst things that have happened to you that you believe are sexually harassing. Now, I have to believe that if you're calling an attorney about a sexual harassment case, you've got something on your mind. And you may not be able to give me the 12 things that have happened over the course of the last year, not right there on the phone, but if you can't give me the one or two worst things, we're probably going to conclude the call with figuring you don't have a case, or at least we're not able to help you. So my suggestion to those of you out there, so that it doesn't sound overly harsh, is before you call the lawyer, make a few notes. Have them in front of you. Make sure that you know what you want to tell us, so that in the course of talking to us and us asking questions, you don't forget to tell us something significant that you really wanted to tell us. These conversations, with Cheryl or I can get fairly detailed. And sometimes we may go down the wrong tangent because we're hearing something. But you may have something else you really wanted to convey to us. Make sure you know what it is. And if it takes, jotting down some bullet points and a few notes, I think you should do it. That way, at least, you make sure you tell us what you wanted to tell us.
Well, you should really have in the forefront of your mind the reason why you picked up the phone in the first place.
Yes, I would think you should. Which leads into...
Is there apprehension? Are they a little nervous about the whole...
Yes.
Okay.
Oh, yes. Sometimes that...
I don't know you. I'm on the phone with you, but I'm going to tell you these things.
Yes. Sometimes that definitely does happen.
Okay.
They're depending upon the type of case, again, sexual harassment, tell me what he said. You may not want to repeat the words.
Mm-hmm.
You may not want to describe it. You may not want to talk to me. You may prefer to talk to Cheryl. A lot of times even we'll have you come in for a consultation, and I can sense that the woman does not want to tell me all the details right up front. She hasn't really gotten to know me yet.
Mm-hmm.
And I'll excuse myself. Let her talk to Cheryl. Have Cheryl come back to me in my office and tell me what she said,
mm-hmm.
so that I can then go back in and ask a few more questions or give some advice, give my thoughts, without having to have it repeated to me. Now, I have to tell that person, it could be sexual harassment or any other type of case, very soon you're going to have to be able to talk to me. So if you don't think you're going to be able to do that, tell me now. Because, next week, 2 weeks from now, I'm going to be asking you questions because I'm the lawyer. And you're going to have to talk to me. Now, hopefully, after an hour and a half consultation, if you're going to say yes, if we're interested in the case and we're willing to represent you, and you're going to say yes that you want us to represent you, hopefully in that hour and a half, you've developed some comfort level, some rapport with me, some feeling of, I want him to be my attorney.
But if you get to trial, you've got to tell everybody that story, so you better get used to telling it.
And we do discuss that. And That leads into other types of people that call us. But really the next one that flows from this is those who call, I'm calling for a friend. No, a real friend, not like,
Okay.
or I'm calling for a member of my family.
I got this friend and they got a little problem.
Or I'm calling for a member of my family.
Okay.
Those are fine. For an initial telephone call, we can deal with not talking to the actual prospective client. But again, please know what you want to tell us. I mean, we know that you're not going to know down to the 7th level of detail because it's them, it's not you.
Right.
But if you're calling for them, if you're calling for your father or your daughter or your son, or your sister, at least know enough to give us basic information that we can try to assess the case. Because if you don't, there's really no purpose to the phone call. And, it's important for those who may be listening to really understand that because it's not that we don't want to help, but we can't even assess anything on a phone call if we don't have a certain amount of facts. So then we got, another very important one, and it's happened. I've taken this type of client through a 2-week trial and saw exactly what happens and why I should listen to some red flags when I see them as a lawyer. The person who comes in for a consultation, whatever the case, and you can tell that for whatever reason, they're likely not to make a good witness in a deposition or at trial. Either because they're really not able to effectively speak about what happened in a way that sounds credible or intelligent. It's not, I don't know, I don't remember, because that doesn't help. Or here's the really bad one, and hopefully nobody out there will fall into this category.
Usually when something bad has happened to someone, and usually if you need a lawyer, something bad has happened, those facts are very clear to you.
Well, so you'd be surprised. They're not always. You may think certain facts are important. You call us and it's about this type of a case. And we hear something that tells us it's not that type of a case, but it is a case. It's just not the case you thought you had. Mm-hmm. And so now we're asking questions to take you down a different road.
Okay.
Now there you may not be prepared for that. And, we try to ask the questions, and if we hear enough, we'll bring you in and, have you bring documents and things like that. And, have a lengthy consultation. But, for the person who comes in, it's one thing to be angry. I get angry. I get angry after I talk to some attorneys on the phone. I get angry after I see some emails. So it's one thing to come in and be angry. I can understand that. It's another thing when I perceive that the person will never be able to tell their story without coming across like an angry, vindictive person bent on retribution. That will not sell in front of a jury. Now, I'm going to give you an example from, let's say, 10 years ago, approximately, maybe a little longer. Well, actually, let's see, really longer. Not the 2004 hurricanes, but there was a hurricane a few years after that.
It was Wilma in 2005.
Okay. Well, wasn't there another one like maybe a couple of years later? Because I started my own practice in 2006.
Yeah, we jumped from Wilma in 2005, which was at the very end of the year. Actually, it was a very late.
It may have been Wilma, because they were one of my first clients.
It was a very late hurricane. Okay. And then we waited. We didn't have really anything until Matthew.
So it may have been Wilma. Get a family, father initially, who calls, very upset that the police tased him, his wife, at a parking lot of the shopping center where they were after a hurricane had made their house unlivable, and they were there, trying to get money, trying to get some food. They had 2 kids in the car.
So they were panhandling.
They were panhandling.
Okay.
And it was down somewhere in Broward County. And they're parked or stopped in the fire lane in front of Publix. And the father and mother are outside the car, panhandling. And a deputy pulls up and tells them they need to move along. All right, under those circumstances, maybe you don't enforce that no stopping standing rule as strictly, but okay. So.
But now we don't know if Publix called them to come get them out.
We don't. But so the parents get back in the car. The father is the one behind the wheel. And as he does, the deputy's walking back to his vehicle, and the father yells back to the deputy, "F you." Now, you want to know something? That is legal. You're allowed to curse at a cop. Cops are supposed to be trained.
Yeah, but now they're going to see if the little light on your on your license plate
Let's not even go there.
Let's
not even go there, because that's illegal.
But you've invited trouble.
But no, you haven't. No, I'm sorry. No. They are supposed to be trained to ignore that.
Yes,
it's
they
free
are.
speech.
Mm-hmm.
If they haven't been properly trained or they don't, then they're in the wrong, and that's when I come into effect. That cop should have walked right back into his vehicle as long as they started moving along, and that would have been the end of it. But it wasn't, because the cop got bent out of shape. So they start moving along, and he's following them through the parking lot. So they go all the way to the other end of the parking lot, and next thing you know, the lights go on. So they pull into a parking spot down at a part of the parking lot where there's nobody, because it's post-hurricane and most stores aren't even open. Publix was open. Turns out on that end of the parking shop, a bagel shop was open. They park where there's virtually no cars, and the cop starts hassling the father, tells him to get out of the vehicle. I am sure that my client was not polite. Okay, I'm sure of it.
Mm-hmm.
But next thing you know, he's being thrown to the ground, and he's being tased twice. The wife gets out of the passenger side of the car, hearing what's going on, and of course is told, as she should have been,
Get back in the car.
Get back in the car.
Mm-hmm.
Well, she ignores the deputy's instructions, and okay, that part is on her. But from eyewitness testimony, which I'll get to in a moment, she did not do anything that would have caused a deputy concern for his safety or his life. Yet she is shot with the taser too. Not a taser what you put on the body. They have a lot of them. You can either put them on the body or shoot the projectiles.
Mm-hmm, mm-hmm.
So she shot twice with the projectiles. So now mother and father are down, and you have 2 kids in the back seat, screaming bloody murder.
Mm-hmm.
The father begins to come to and sees somebody coming out of the bagel shop and is yelling, "I need you as a witness. I need you as a witness." So they're arrested. Charges are dropped. DCF comes and takes the kids.
Mm-hmm.
Does finally get them to relatives, thank goodness. And ultimately they find their way to my office looking for a civil rights lawsuit. Now I hear the first thing that the cop, doesn't ignore the curse. Instead, follows them, pulls them over, supposedly for not doing anything wrong, because again, there was, thank goodness, one eyewitness. And when we get to trial, I'm really excited about this case, honestly, because I have an expert on police procedure who is the former chief of police of a very large southern Florida town. So he should come across as an excellent expert witness.
Mm-hmm.
And I have my eyewitness. Oh, I know there's going to be 5 or 6 cops who are going to be lying to me because other cops showed up.
Yep.
And I'd taken their deposition, so I knew how I was going to have to attack them in cross-examination. But my eyewitness, you'd think one eyewitness, how good is that against cops? Well, my one eyewitness happened to be a retired detective of the NYPD. And he saw it all.
Coming out of a bagel shop. How appropriate.
That's right. Well, it wasn't a donut shop. It was a bagel shop.
Yes, but New York.
That's right.
Bagels are big in New York.
And he testifies against all the cops, 100% on the side of my clients. They didn't do anything to justify the tasing. This was all one cop just gone nuts. And it all started with FU. So I figure I have my expert. I got my great eyewitness, a detective from the NYPD. So, a jury's not going to just think, oh, this is just some person. A jury's going to think, well, this guy, and this is what I'm going to argue to the jury. You would think that this guy is probably, if it's possible, going to give the cops the benefit of the doubt and side with them. But he didn't, so that should speak volumes to you. Now, here's the problem.
Your client's angry?
Well, the mother was angry, but I thought in preparing her for deposition, in preparing her for trial, I had effectively done a job of getting her to understand if you come across like that, the jury won't like you. If they don't like you, you're going to lose. Because it's not just facts and law. It's emotion. And so you can't come across like that. And by the time we were ready to go to trial, at least with me in the office, when I was preparing her and asking my questions and cross-examining her, as the other side might, I thought she was going to do a decent job. And she did. She kept it together. The father was always a difficult one. Because not only was he angry at the incident, but he just was an angry person. And although I was able before trial to tamp him down a bit, I was worried about what was going to happen on cross-examination.
Well, that and the officer was in the room too, wasn't he?
Well, a number of the cops were in the room because we sued a number of the cops. What I didn't expect was that he was going to get really nasty and cantankerous and in response to my own questions.
With you. No.
And then when cross-examination came, oh my goodness, he was the least likable person you could ever imagine. Guess what?
They lost.
We lost.
Yeah.
And afterwards, when I am debriefing them, and they ask why I think they lost, I'm trying to be a little bit diplomatic. But he is pushing a little bit for a little bit more detail than I was trying to give. And I finally looked at him. I said, look. Called him by his first name. I said, you didn't listen to me. You were a horrible witness. You yelled. You argued. You were nasty. If the jury had liked you, you might have won a big judgment. You had the expert witness. You had the NYPD detective. So honestly, when I'm debriefing even myself later on, as you always do a lawyer in a trial, whether you win or you lose, you start replaying the whole trial. Mm-hmm. Evidence that you couldn't get in, why couldn't I get it in? Things that went right, things that went wrong, things that you didn't anticipate. Why didn't you anticipate it? You debrief yourself. Mm-hmm. And I got to tell you, in that particular case, as I debriefed myself then and later, I only came up with one explanation for losing the trial. And that was him.
The client.
So the moral of the story is when a client comes into my office now, it's been 10 years or so later, maybe 12, and in the initial consultation, the client presents to me as somebody who is not going to make a good witness. And that doesn't mean that the person is upset or frustrated or even angry. That's okay. But there's something beyond that when you see it and you hear it. And I've learned my lesson that when those red flags go up...
That would be their character, I think.
Well, maybe. But when those red flags go up, I have to listen to them and maybe turn down a case that I think is a real case.
Because if you go back to him being in the fire lane, had he just went, okay, thank you, Mr. Officer Man, have a nice day, his whole day would have been totally different.
You're right, but you want to know something? It doesn't matter. I'm sorry. You are right. But telling a cop to F you is not against the law. And I don't care what anybody says. Oh, if you'd only been nicer. You're right. But the fact that he said F you to the cop did not justify anything which happened thereafter.
But there's a process when you get pulled over. There is a process that no matter what you might think, he's the first judge you meet.
Yes, but there's also laws. And it is a civil rights violation to start going after somebody just because they cursed you. And then to use excessive force and to tase them and to do it in front of their kids when they did nothing wrong legally. When the only legal violation you can find is the curse, which isn't a violation.
But see, that was what sparked the second pullover.
I'm sorry, I don't care. It doesn't matter to me. The deputy was wrong. It should have been trained better. And we do have a call. We have John on line 1. Hello, John.
Hi, how are you?
I'm doing fine. How can I help you?
Hi, Veronica.
How are you?
I'm good. First of all, I wanted to say how much I enjoy your program.
Thank you.
And I hope everybody listening appreciates the valuable information and input that you give. I mean, it's been hundreds to get what you give for free on the air.
Thank you. I appreciate that.
Sure. I wanted to tell you a couple of experiences I had way back in '03.
Okay.
I was with a lady friend, and I turned onto Port St. Lucie Boulevard, and there was a police car at a stop sign on a side street. So I turned onto the boulevard, headed west, and he came around from the stop sign and followed me and pulled me over, and he said, "You don't have a sticker on your plate."
Okay.
So I said, "Oh, I'm sorry, it's in the glove compartment." Well, he wrote me a ticket for $58.
All right.
And then he said to me, "You impeded my right of way." So I said, "Wait a minute, you were stopped." I said, "I was traveling on the boulevard, So he wrote me a ticket for $85, and he was training. He had only been on the force for about 3 months.
Okay.
So I went to court, and he was questioned, and he gave a lot of bad information, and the judge said, "You don't know what you're talking about. You would have had to been on the wrong side of the road, going in the wrong direction, blah, 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 So he asked his training officer that was with him, and the officer said, "I had my head down doing paperwork. I didn't happen." Well, anyway, the judge says, I'll take it under advisement, and now you'll be notified by mail. And they sent me a check for $95. Not a check, but a bill for $5. So now about 6 months later, I'm in a parking lot, and I'm leaving the lot, and a lady tries to get around me. She was in a hurry, and she scraped the corner of my bumper with her doors.
Okay.
So a lady came over, and a young lady, probably mid to late 20s, and she said, "I saw the whole thing. She was in a big hurry. I'll be your witness." So I call the police. They send a motorcycle cop with not the best reputation. And I told him what happened, and he knew the lady. She was a realtor.
Right.
So he walked over to my witness, and when he came back, he said, "Your witness says it was your fault." So I didn't want to argue after the experience I had in the court with the other one.
Right. As Veronica says, it's always a good idea not to argue with them.
Yeah,
Well,
that's
I
what
didn't argue at all. No, because I said, "How come my
especially in
witness
Port St. Lucie. I'm just saying.
Yeah. Well, they've come a long way, and I know a lot of people now. I knew only a few then, but it's a couple of bad experiences. And I want to tell you a humorous story, and then I'll get off.
Okay.
Many years ago, we're talking 45 years ago, I knew a fellow named Sam, and he was less than honest, and he was an older man. And another buddy of mine said to me, Sam was in the paper, the local paper. He was robbed. They took a stereo and a television and, all this, the usual stuff.
Okay.
So he said, let's go see if he's all right and what happened. So we went to his house, and he said, Sam, what's going on? Are you okay? He said that they do any damage. He said, what are you talking about? He says, your ad is in the paper that you were robbed. He said, oh, my son put that in. That was supposed to go in next week.
Oh, my gosh.
True story.
Well, you I don't know. Yeah, that's a good one. I hear a lot of them with the calls to the office. But thank you for calling in.
Okay. Thanks for listening.
Yeah, you take care. All right, a couple of amusing stories about police and others who are less than forthright. Let me switch topics for a second and try to do a real service.
Sometimes women are pulled over because the officer would like to meet them.
I believe that. That's called driving while pretty. It's a DWP.
Yeah.
I just made that up.
Yep.
Yeah, I believe that. I really do. What can I tell you? And sometimes they pull you over because they want to meet you because you're pretty and they're already married.
What a world.
What a world. Let me switch topics to the topic of contingency fees for a moment.
Okay.
This is something which has just come up in my own office. We settled a very nice case, an employment case, for a very nice amount of money. And the fee agreement that was signed is the traditional fee agreement, is not in personal injury or products liability, things like that. It's 40%. Now, of course, a lot of people who don't deal with lawyers, they always are familiar with the 1/3, but they're not familiar with 40%. Okay. You explain it. They understand. They sign the representation agreement. Well, now we get a nice sum of money, and sometimes people want to keep a little bit more of it. So it's like, why is this 40%?
But 40% of nothing is nothing, and 40% of something is you've still got something.
Well, remember, they got 60%.
Right. But what I'm saying is you would have had nothing otherwise.
Right. So in the course of discussions, I have a client who sent me a cut and paste from the Florida bar pamphlet on contingency fees, telling me that it should have been a 1/3 agreement, and that the agreement I had her sign was an illegal fee agreement. So I had to respond by cutting and pasting the first sentence of the paragraph that she referred to, which says that this deals with contingency fees and property damage only. That's what the 33 1/3 deals with. But more important, let's assume, because I've had some of these cases, thank goodness. Let's assume your fee, whether it's 1/3 or 40%, whatever, is an extraordinary fee for what turned out to be less work than you anticipated. So that your effective hourly rate, I don't know, is $500 an hour, $1,000 an hour, $5,000 an hour. Client sometimes says, well, that's not fair. I want to try to explain to you why attorneys have contingency fee agreements and why they're fair for both sides. And maybe it'll help avoid some misunderstandings down the road. There are certain types of cases which traditionally utilize the contingency agreement because the clients generally can't pay.
Mm-hmm.
People who call about an overtime claim, they're not going to pay me my hourly rate to try to get them less money than that.
Right.
Discrimination. These are usually employees who, if they're not living paycheck to paycheck, they certainly don't have a reserve fund to pay me an hourly rate for 2 years, to try to get them a lot more money than that. They're contingency fee agreements. And sometimes you're fortunate, and they're fortunate too, frankly. The case settles for an amount, or you win a trial for an amount, that makes the work that was done by the attorney, hourly, in terms of how many hours we put in, seem extraordinary, unfair, highway robbery. Attorneys take on contingency fee agreement cases for two reasons. One, because they know that there are certain types of cases you as a client are never going to hire them or any attorney if it's not a contingency fee agreement.
Well, because
So-
they just probably can't. They
Right.
They.
And so you're getting an attorney of your choice, it doesn't have to be me. You're getting an attorney who is willing to take a risk in the time he puts in, or she, that they may get nothing for you. That happens plenty of times.
Mm-hmm.
Or what they may get at the end leads them to making $20 an hour. Or something along those lines where, from the attorney's perspective, it would have been better off for me as a business if I had never taken the case.
Mm-hmm.
But we take on that risk just like you take on certain risks. And you have an upside that you wouldn't have had if you didn't have a contingency fee agreement. And the attorney is hoping for an upside. The attorney is hoping the better he or she does for you, the better they're doing for themselves. So why is it, I'll say from the attorney's perspective, and call in and feel free to disagree with me, argue with me. It's a good topic to air out. Why is it fair if it turns out I'm making $5,000 an hour? Which is, unless I'm a ball player or something absurd. It's fair because it offsets those other cases where nothing is earned, where you put in so much time for so little recovery that you're making next to nothing. And every attorney is looking and hoping for those cases, solo practitioner like me, maybe 2 a year, that not only compensates for the ones that didn't do quite as well, but frankly helps you earn your income and, continue on. And so while it may seem, $5,000 an hour.
But who would break it down? I mean, I guess the client, because they're seeing the check and they're seeing what they would have had you got nothing.
Well, actually,
But-
they don't see that.
But why would they break it down hourly? Because
I'll tell you why.
I mean,
Generally,
when you pay a realtor, you don't break it down hourly. They get
You're right.
they get a fee.
the client generally doesn't see the hourly number of hours in a contingency case because they don't get the same type of a bill, the same type of invoice. They get a closing statement, like at a real estate closing statement.
Okay.
They may never know I spent 573 hours on the case. Okay? They may never know I spent 20 hours on the case. What they know is, gee, this case settled in 2 months and he's getting, how much? That's not fair. So sometimes you hear from them. And honestly, as much as I identify with a lot of my clients, as much as a good number of my clients end up becoming friends afterwards, as much as I take on, emotionally their cause, not just legally. There are a lot of lawyers who are dispassionate, and maybe they're better at some things because they're dispassionate. That's not me. If I'm going to take on a discrimination case, it's because I believe in it, and now my emotions are going after it too. So if you lose, it's not just me that's lost money. I feel I've lost. I feel I've lost personally, and I feel really bad for you. I feel like I let you down because I became to identify with the case, not just be the lawyer. So when you have those contingency fee cases where you make a lot of money as a lawyer, I think most lawyers, including myself, no matter how much I identify with clients, don't feel guilty about it. Because it's what you're hoping for, not only to offset the other cases and allow you to take cases that you might not otherwise take a risk on, but it allows you to make your living. And then you look at it, let's say it's a $100,000 settlement, use a round number. And so my fee is $40,000. Well, if the client was never going to be able to find an attorney to represent them, and if the client was going to end up with nothing, that $60,000 is a good result. It may even be a better result if what you really lost was $30,000. Okay, then I've really done well for you.
Mm-hmm.
And please don't begrudge me my 40. Okay. This is what happens. Sometimes you end up having at the end these discussions with clients who see the closing statement and realize how much you're getting. And now they want to have a discussion with you. And it's a difficult discussion to have with a client. That's why maybe I'm having it a little bit on the radio right now.
Yeah, but to me, you shouldn't have to have that because they knew that going in. Let's say it's discrimination. Okay, well, you could have felt as though you were discriminated against, and you truly were, but you just left your job and went to work at another job, and you never pursued anything.
Right.
That person is getting zip, nada.
Right.
Okay, they came into you with their problem, and you resolved it.
You're right, but I
But
don't.
they agreed to that percentage.
You're right, absolutely, and ultimately, sometimes I have to actually just come out and say that to them. I try not to be that blunt initially.
I mean, how would they feel if you didn't win?
Well, I hear you, but when sometimes when the money is on the table,
Yeah,
the instinct is you want as much of it as possible.
of course.
Okay, and it's a natural instinct.
But it's a partnership. They wouldn't have gotten anything
It
without
is.
you.
But I try to explain it as delicately as I can, as gently as I can up front. And then if pushed, like I was this week, sometimes I have to respond.
Take your check and leave.
That's the agreement. If you don't like it, you can terminate me right now in the middle of negotiating the final dot the I's and cross the T's. I will, take the checks. I'll hold them in escrow. You'll have to get another attorney. You can sue me or you can file a bar grievance. The bar figure it out. But ultimately, if we become adversarial, even if it's at the bitter end, ethically, I have to withdraw. That means even if there are checks coming, even if the settlement agreement's been signed, the checks will come to my office. I don't deposit anything for myself, and you don't get anything.
Mm-hmm.
You get another lawyer. Now, it's never happened in my practice.
Okay.
But it does happen. And, you can end up waiting another 2 years for your money. So, since we have 1 minute left, the closeout to that is, what I really want to convey is, most attorneys that are on a contingency fee, especially if they're solo practitioners, are taking risks. And they're looking to be compensated for the risk. And we hope that as a client, you understand that, and if we've done really well for you, that you're really happy. And most clients are. This doesn't come up all the time. But it comes up enough that maybe a discussion is needed in the public about contingency fees and why they exist and why sometimes the lawyer makes out really great. But let me tell you something. If the lawyer's making out really great, you're making out really great. All right. I guess that about does it for the show. Give Cheryl a call. The office is 781-8003. I hope you all have a wonderful weekend. This is Stuart Address for Ask a Lawyer, and I will be back next Friday, right before Passover. And that leads us into Ask a Rabbi.
This is WPSL Port St. Lucie.